This is my first Zoom conference, so we're going to figure it out as we go. I am a lawyer. I've been practicing 25 years. Molly, you got it right. It is Kaufman, Drozdowski, and Grendell. Well done. And I do have to say that I like Bruce Corson's background best so far. He's got a roaring fire going, so that's very nice. Unless that's one of those fake backgrounds they put in the back. Is that the real deal, Bruce? Real deal. All right. So, I've been a business lawyer for 25 years, and, I've been a business litigator. I've been a corporate attorney where I've worked in-house at a company, and I've done a lot of business work. And what's gone on recently is like for everybody else, it is so unique and it's so different. It's really been a challenge, and, we've got flooded, our firm, and every firm has, with questions about these different laws that are being passed and these different rules that are going into place, and it is moving so quickly. I offered to Molly to do this to try to help out. Now, I can't give legal advice over the telephone or over the Zoom, and that's a sort of a term of art. For me to give advice to a client, I really have to do a conflict check first and make sure we're not running into someone else that we already represent. I've got to also fully understand the facts of the situation. And on this type of scenario, I really can't do that. So this is more intended to be educational and intended to give you an idea of questions that you need to ask to your lawyer or your accountant or your banker, anybody that helps you out. You can do research yourself, anything, but this is intended to really give you a heads up about some of these changes that are happening really fast. So, what I'm going to do is I'm going to go through 5 topics pretty quickly, and those topics are, first of all, that stay-at-home order. There is a lot of discussion about that going on right now, and I'll give you a little bit of insight and some information I've seen to help you figure out what's going on with that. For small businesses, probably the payroll protection program is the biggest issue in my mind that's out there now, and that's this ability to obtain a loan. It's a pretty cool program, and I'll give you a little information on that. And as you see me talk, you notice that I'm looking up to my left-hand side, and that's because that's where my notes are. I've got my second screen sitting right here, so hope that isn't too distracting, but that's where I'm working from. There's something out there too called business interruption insurance, and this is insurance or coverage that's part of many policies that you already have, and we'll talk about that a bit. Employee issues, there's a variety of issues that have happened and that go on when with your employees, including what is going on with if you need to let some go, and then what happens if you can't perform under a contract, whether you can't pay or you can't do what you've agreed to do. And we'll talk about that a little bit. So, first of all, and then what I think I might do, and maybe you can use that chat function, but when I get done with the topic, that might be a good time whether to raise your hand or to use the chat feature to write a question to Molly, and maybe we can do that while it's still fresh in everybody's head. If not, I'll leave time at the end to talk or to answer any questions. So first of all, this stay-at-home order. First of all, if everybody who's in business hasn't read it, they really should read it. That's the basis for really being in business right now. It says that you need to stay at home unless you are an essential business. And that's created some confusion. It's not surprising. Nobody's ever seen anything like this before. So I read in the paper, the Plain Dealer had an article the other day that the Cuyahoga County has received 1,500 phone calls about the stay-at-home order, of which 554 were whether someone was an essential business. So there's questions out there. The question too is this being taken seriously by the government? Well, I think you see the governor and the lieutenant governor and Dr. Acton, and they're taking it very seriously. The article I read, though, said that Summit County has closed 37 businesses already because they found that they were not essential under the act. Cuyahoga County has received 312 complaints, and they say that they're beginning investigations. You know, the question you have though is that how do I find out if I am essential or not? Our lieutenant governor said that we shouldn't be calling police departments and departments of health right now because they're overwhelmed. They've got so many things going on. And Governor DeWine said that he doesn't want to be making arrests or issuing citations about whether someone's essential or not. He's encouraging the authorities really to talk it through with people. So they're trying to get people to help. So I've read the order myself and looked at it and thought about it. And the way it's drafted is it starts out broadly, and it says you need to stay at home unless you're essential. So the premise is stay at home. So that's where you start off, and then it lists a bunch of exceptions. And if you're clearly within an exception, you know what your you have some ability to continue to work, provided you do distancing and the other items that they describe as being necessary to prevent infection. But the issue is always with the gray areas. What if you're in the middle? And that's where the questions often lie. And I'm sure those 554 people calling up Cuyahoga County, they're mostly in that gray area. So what do you do? Well, from a lawyer's perspective, what we do when we try to figure out what a law says is we try to figure out the intent of the statute or the intent of the law. And when you're talking about something that the General Assembly passed, it's not always that easy because you've got a whole bunch of people in the General Assembly, 50 people, 60 people, whatever the number is, voting on something. Here, we have an order, and it was written by Dr. Acton, and it was coming up, through the governor. We pretty much know what they're saying is what their intent is. And even better than that, the order in a provision there, it says intent. So it makes it pretty easy on us. And it really says that the intent says what you would expect. It says is that we want people to stay at home. So, that is I can't give you much better guidance than that, but the gray areas, I think you have to lean on the side of staying at home just because that is their intent, and that's where they're going with this. What did DeWine say though? And again, back to this article I read, and what did Lieutenant Governor Husted said? They say that they're going to try to interpret it with using common sense, and that's encouraging because I think they don't want to use a heavy hand unless they have to. And Lieutenant Governor Husted said he wants people to use good judgment, but he gave a very practical suggestion. And he said that if you're struggling and you don't know, if you're in that gray area and you don't know whether you're supposed to be operating or allowed to be operating or not, he said that create a document, lay out your reasoning for doing what you're doing, and then also list down what you're doing to keep your customers and your employees safe. And I think something like that's done, especially before you get questioned. But it's something that you showed why you're doing what you're doing. I thought that was a pretty good and practical suggestion. Any issues or questions with the stay-at-home order? All right, well, let's move on.
None on chat either.
Okay. Let's see here. The next item is this payroll protection program. And this came out of this CARES Act, if you've seen. And that is the one that, many people are expecting to get checks in their mailbox or wired into their accounts very shortly with some money. But there's a lot to it. And I read really closely a summary from the Feds, which was 35 pages. And I even looked at a good portion of the 800-page law to try to see what it said. Because a lot of times with these things, the devil's in the details. But I do think they're going to be trying to be helpful with people and not be too fine, because the idea with this bill is to help businesses out. They don't want, they want people to stay at home, but they don't want to gut our business community, and that's where they're going. what's kind of interesting with this too is that it applies to small businesses and but also nonprofits. So it's open, but it's even broader than that, which is sole proprietors and independent contractors and self-employed people. You can all seek to get a loan under this payment or payroll protection program. The loan amount is tied to your workforce. So it's either the lesser of $10 million or 250% of your payroll. And then what can you use the money for? Well, things that keep you, in essence, working and up and running. That's payroll, that's sick leave, that's insurance premiums, rent payments or mortgage payments, and utilities. So, a lot of good things can be used with this money to try to keep you going. It's structured initially as a loan. So the loan can go up to 10 years and the maximum interest is 4%. But what's really cool about this is that there's also forgiveness. So it is a loan to start, but it can be forgiven if you mainly keep your workforce intact. That's the kind of the overall theme of this, is that it's trying to keep, well, it's payroll protection program. It's trying to protect your payroll. It's a lot of P's at one time there. So that is an important program. I'll tell you right now that it's not fully up and running as far as I can tell. I've got a good contact at actually Huntington Bank, because they do a lot of SBA lending, and they're still working on the guidance. The SBA has to put this into place. It gets passed by the federal government, but then the SBA has to figure out a program to make it work. So they're working, their backsides off to try to get it put together. And then they're working it through banks. So the banks then need to figure out what the rules are and put a plan in place. So it's all moving fast, but that's something to really watch carefully. The nice thing too is that's not the only program out there. The SBA also has something they call Emergency Economic Injury Disaster Loans. Now these are truly loans, but there's a way to weave them into this Payroll Protection Act and possibly getting forgiveness. So there's a provision of this which allows for an emergency grant of up to $10,000. So if you need immediate money, that's something to think about too. And then there's other lending provisions that the banks have. So there's a lot of help coming through the SBA. Again, talking to my contact at Huntington, I said, what should people be doing now while we're still waiting for this to get rules about? And what he said is you ought to be pulling together your financial information. So get your 2019, 2020 profit and loss statements together. You might need to call your accountant up, but get your 2019, 2020 payroll reports, any state income or payroll or unemployment insurance filings, your tax ID and ownership information. Get all your corporate records together and have them ready to go, because I think when this gets started, there are a lot of people. I mean, there's $350 billion out there, so there's going to be a lot of people who are going to be moving for this. So you want to be ready to go, because this is important protection. That's it on payroll protection. If there's any questions?
Yeah, I have one. One more time. Can you go over what's the roster? Because I spoke with Huntington myself this morning, and she said, yeah, things haven't actually got rolling, and she doesn't know when it's going to go live. Other banks may be preceding other banks. But what, again, is the list of things I should have beside the tax ID? How many years of income tax returns? Well, what exactly? Because my accountant said different. Well, no, maybe that was a different thing. So you just answer, if you could, please. Yeah,
and this is just going by what my friend at Huntington said, but he suggested having 19 and 20 monthly profit and loss statements. So 2019, 2020, what you have up till now. 19 and 20 payroll reports, state income, payroll, and unemployment insurance filings, tax ID and your EIN, and your ownership information. And just to say it, this might be, I know a lot of business people don't necessarily have, filings where everything neatly put together, but if you're finding yourself with a little extra time, this might be a good opportunity to organize your corporate records and really get all your documents pulled together. Because there's, this is just one program, but there are other programs out there, and you want to be able to move quickly when you have the opportunity, so you can get assistance if you need it. All right. The next topic is business interruption insurance. And this is coverage that exists in many business policies. Now, just to say about insurance policies, I've done a lot of work with insurance. I worked for an insurance company for 10 years. But these liability policies, if you've ever looked at yours, your general liability policy or your business policy or even your property policy, they're usually thick and they are very complex. And that's a problem, but it's what you have to deal with. Many of these provisions, many of these policies have provisions which talk about business interruption coverage. And if you talk to an insurance company or you look on their website where they describe this coverage, their viewpoint is that it's for if a tree falls and destroys your business and you can't operate anymore, or a tornado hits. They're usually looking at it as being some impact to your physical building. Lawyers who do coverage work, though, and who do this type of litigation, they don't accept what the insurance company says because it's really what the policy says that governs. So there have been a lot of cases that look at, for instance, asbestos in a building. So you don't have the building being, any destruction to the building or any damage to the building, but you have fibers floating around, asbestos fibers, and they presented claims and gotten coverage in cases under this. So the idea is if there's a virus floating around in your business, you might have damage to your property. The other piece is that a lot of these policies have provisions that talk about civil authorities. It's not that you can't operate because a tree knocked down your building, but you can't operate because a civil authority told you couldn't. So you start putting together some of these arguments and some of these provisions that may be in some of your policies, you might have a good argument for coverage. Now, I will warn you that coverage cases can be complex. They can be time consuming. So, it's something you have to think about carefully. But the first step is to see if you have coverage under the policy. Now, you take it to the next step. And again, these can be difficult cases to bring and difficult arguments to make. And insurance companies are going to be pushing back on it. But what's happened recently kind of adds some makes it a little more interesting. And that is in our General Assembly, there's been a bill introduced which in essence is going to require insurance companies, if they have the right language in the policies, to pay these claims. And you can imagine that the insurance companies will be fighting back against these bills. There is a little sweetener in it for the insurance companies in that they say that they will, the General Assembly, and really through the Department of Insurance, they might reimburse some of these claims if they're paid. And how they do it is kind of long and convoluted, but it could be that if you've got the right language in your policy and this bill passes, there might be a better opportunity to get business interruption coverage from an insurance company. So that's something to monitor and to be aware of. Any questions on that? All right. Now, dealing with employees, a lot of people are letting their employees go right now, or they're putting them on furlough, and it creates all kinds of issues. And I really can't, get into every issue out there because they're complex. There's a lot of law that relates to employees, but there are a couple of topics that I thought I'd discuss. There are employers who are looking at their workforce and they're like, look, I can't continue to pay them their salary right now. And, hopefully you get that payroll loan and that helps out. But they say, but I don't want them to lose their health insurance. But insurance policies have a provision that usually require for health insurance that the employee be actively at work. So if you let them go, they won't be actively at work anymore. So the Department of Insurance has put out a bulletin, and what it says is that they're trying to limit insurance companies from doing that under these circumstances, under this emergency. So where you may have some problem with having coverage, there's now a bulletin out there from the Department of Insurance which can give you some protection if that's something that you're considering. I'd encourage you to look at that bulletin if that you're considering maintaining health insurance. The bulletin does a couple other things though too. Is it does put some prohibitions in on raising premiums during this time, so that's good for people who are paying for health insurance. And it also has a 60-day grace period if you can't pay your premium, so you don't immediately lose your coverage. So, if health insurance is an issue, it would be a good idea to take a look at that bulletin. Now, if you're a bigger employer, this is the next topic. If you're a larger size employer, say you have 100 employees or more, and you're looking to furlough 50 or more at a single site, there's something called the WARN Act. And it is what it sounds like. So it says you need to, in essence, put a filing into the state of Ohio and put your employees on warning that they're going to lose their jobs, and you really can't do it until 60 days out. So if you're a bigger company, you really need to be aware of that and take that into account if you're looking to furlough a large part of your workforce. Now, if you are a company that that is allowed to continue to operate, so you're one of these essential businesses, you've got to be cognizant of safety issues, and that's where OSHA comes in. It's safety issues for really your employees, but also for the people who are coming in. And OSHA just recently created some very good guidance on how to make your workplace a little safer. And it's called Guidance on Preparing Workplaces for COVID-19. I would recommend it as being something that you might want to look at. If you've got people coming into your place and your employees who are working together, it's well done. I'll also say that in the stay-at-home order, there is some good guidance in there too about keeping your workplaces safe. So I'd also encourage you to look at that. What this OSHA order does is it divides, among other things, and I will say too, it's only like 30 pages, so it's actually pretty readable. But it divides workplaces into 4 different types based on risk. So there's very high, medium, and low, and it gives you some rules to follow within how you gauge your workplace. And it's good. I can't imagine all the legal issues that are going to come out of this situation, but if you're following what the government tells you to follow, that is a good first step in making sure you can respond to some of those legal issues. And document what you do. If you read the OSHA guidance, you document that you did it, and then document what you did to try to comply with it. You can't imagine how this is going to all play out, but I think even where we're at right now, nobody could imagine that too. So it's something to think about. The last issue I'll raise is it's called the Family First Coronavirus Response Act. So this was passed by the feds, and it was really the first thing that happened as far as trying to give some relief to employees. And what it does is it creates some rights to paid sick leave and expanded family or medical leave. And what it does too is it applies it down to smaller employers. It defines it as applicable to companies with less than 500 employees. There are some outs if it's really going to harm your business, and then what they do in order to try to help you out is that there is a tax credit. So if you're in a position where you need to start getting sick leave and expanded medical leave, you want to talk to your accountant because there are some tax credits there. The other piece being this loan, again, this Payroll Protection Act loan, paying sick leave is an item you can use that money with or use that money for. So while this has all come in a variety of directions, there is a bit of a rhyme or reason together, and there is some consistency and some effort that where obligations are being posed on people, some money and some funds are being given to try to help people out. Any questions with those topics? Again, we can leave some time for questions at the end.
Henry, I have a question, and then
Yeah.
I know Matt has a question also. If you are a small business and you know at this point that you are not going to get through this, you're just not going to be able to get through it. Is there something that those small businesses should be doing right now, to help this inevitable close of their business, or do they just need to ride it out and see where it goes?
Well, I mean, if you know you're not going to make it, you have one of two options, really. If you can pay off your claims, then you can do what's called a winding down, and that's just, an orderly ending of your business, and the law explains how you do that. And for the most part, if you can pay your bills, you pay your bills, and a few other things to wrap up, but that can be done fairly easily. If you can't pay your bills and you want to try to stay in business, there's bankruptcy laws, and I will touch on. I was planning to touch on that in a minute with what happens if you can't pay your bills, but there's bankruptcy that's out there, and nobody likes bankruptcy. For the last multiple years, there have been very little bankruptcy filings, and the most bored attorneys in the business attorney world have been bankruptcy attorneys. And that's because it's been really good times. But the overall idea of bankruptcy is to create a fresh start. So it's not supposed to be onerous, or you're not supposed to wear the scarlet letter after you file for, or the scarlet V, I guess, after you file for bankruptcy. It's supposed to give you a fresh start. And the way our system is set up, in a capitalistic society, you want people to try to start new businesses and to build wealth and to hire people. You want people to do that. And if it doesn't work, you don't want them to be burdened forever with all of the debts that would go along with a failed business. So, if you've got to consider bankruptcy, sometimes there's different types of bankruptcy. There's liquidation and there's restructuring. So sometimes bankruptcy is a way to restructure your debt so you can continue to move on. Other times there's a way that it just allows you to wrap it up and to be done with it. So that's something to consider too. That's sort of the worst case scenario.
All right, Matt, do you want to ask your question?
Yes. In brief, I typed it out. What about situations where my company is an essential producer? We produce for the Department of Defense and the CDC for direct items that are being used right now for the fight. And we have employees that, have decided not to work. And I know I'm not looking for direct advice on that, but just any thoughts on, how do you handle employees that do not want to work?
Well, this goes back to the, I think in this situation, you've got to be careful, because there are some rights to family leave that would allow them to be out. There are some rights to, the question is, I guess, are they sick themselves? Do they think they might be sick? Or do they just not want to work? You start with the premise that an employee needs to go to work. And if they don't have an excuse, then, you can discharge them if they don't show up for work. That's sort of the top level piece. Then you got to break it down a little bit. Are they telling you something, each one individually, why they can't work? Is it because they have children at home that need to be taken care of? Is it that, they have felt tightness in their chest and they're not aware, they're not sure what their situation might be? Do they have a neighbor they're trying to help out? That's that there is a lot of kind of issues you got to kind of dig down to and understand before you let someone go under these circumstances. It's just a different world right now.
Okay. It's for a multitude of reasons. Fortunately, none of them are sick. And a lot of this occurred, when the shutdown of businesses first started, and they would just have concerns. Let's say they're living with an older person or underlying medical conditions that they didn't want to expose themselves to.
Yeah. I'd have to think about that a little bit more. And if you'd like to talk offline, we can talk
Okay.
about that. Yep.
Thank you.
Sure. All right. Molly, do we still have time, or how are we looking?
Yeah, we're good. I think Dave Straw, let's see. Dave Straw has a question. And then after Dave Straw, Bruce has a question too.
Okay, Dave?
And I can just ask it. I mean, I think going back to the last question, well, one of the main reasons I'm getting, people want me to lay them off so that they can collect the government's extra $600 on top of it. And I don't want to lay them off. I would like to keep them reasonably productive, even if it means putting to work in my own house or in my own office, as their income will be ultimately reimbursed. So if I deny that unemployment, I mean, if we've never had to have layoffs here, so I don't know how the unemployment works. Can I basically deny them or say that they've quit if that's what their tactic is? You follow what I'm saying?
Yeah. Again, I do think that the and again, this is probably something I have questions that I would follow up with, and this is probably not the right forum to do that. Dave, we can talk offline if you'd like on that one too.
Okay, thanks.
Yeah.
I think, Henry, if I'm not mistaken, you and I have had this conversation. I think somebody can put staff on unemployment, and then once they get the loan, they can bring those folks back and use that money without hindering their ability to get that loan.
And that's true. I to some degree, I think, Dave, what I'm hearing your question being is you want to just kind of keep them available and ready to go in the event that things improve and you need folks to be up and running. Is that?
Well, that's part of it. We actually have crews in the field working according to a good interpretation of the stay-at-home order on exterior projects or required projects. And those folks are looking at what, and I hate to say we underpay them, but our minimum is $15 an hour, which I think is pretty darn good. But they look at what they can collect on unemployment versus actually showing up and going to work, and that's more attractive to them. So my goal would be to try to keep them employed, kind of against their will. But
yeah, sometimes the easiest way to answer these type of questions is to kind of look at the big principles, because everything is streaming down from the big principles. One of them is that they want people to be, really staying in and not outside unless it's really essential. And the other principle you're getting is that they're trying to make money available to people who, in essence, are in the companies that comply with that or who make an effort to do that. So you're kind of going upstream a bit, whether there's some, dance that you can do that lets you get where you want to go. I just can't say that now as I sit here.
Understood. And broadcasting is probably, this is a good conversation for later on.
Yeah, that's right. Bruce?
Yes, verified. Beth said that listed the things we need to have as you talked about it, and said they have to be verified. I have a meeting monthly with my bookkeeper. I get profit and loss statements, everything. It's all from him, but there's not a notary stamp on it or anything. What's verified mean?
Yeah, I don't know that verified is a requirement. I don't no. I with the information that I got, didn't say they had to be verified in any way. What I do know, though, is that you'll have to sign a certification that the information you're providing is true and correct to the best of your knowledge. But as far as having a notary stamp, I don't think that's a requirement.
Okay. Okay,
I
thank you.
I don't know for sure. I put that in. That was the information that I received from KeyBank. So they're in the same boat as Huntington. They're the 8th largest lender for SBA loans in the country. So we bank with them anyway. But that's what they told me to start preparing. That was their verbiage.
Yeah, and we might
In
be
my
thinking,
mind, I think my accountant review is probably going to be enough. I would hope.
Yeah.
and
Could
we,
I, a follow-up. You mentioned a couple of banks. My business account is at Chase. My personals are Huntington. Yeah, I'm going to apply through Chase, but is there, I mean, does one get access to money first, or these guys just go betweens, and does it matter?
yeah, and that I don't think anybody gets. I think they're using their own money to make these loans, and then they just gets guaranteed by the SBA. That's the first answer. The second answer is that you want to go to a bank that that has the ability to kind of lend on the full panoply of options. If your bank, now it sounds like KeyBank is a SBA lender. I know Huntington is an SBA lender. There are several SBA programs, and this payroll protection program. If you read the law, there is a authority for other banks to make those type of loans, but not the other existing loans that were already out there. So, you know, if you don't have a relationship that you want to use, I'd suggest going to one, you know, one who is able to make any type of SBA loan, who does SBA lending, you know, rather than someone else who's kind of on the fly picking it up.
I think Chase does. So
yeah, I would be surprised if Chase did not. So
okay, thanks.
And we have another question. If your business is essential, but yet you're losing money because people aren't like, I'm going to use Bruce as an example here. So Bruce is essential because he's computer and tech, but yet people aren't using him right now because either they're afraid to give their computer with germs and stuff like that. So he's able to work, but he's still losing what he should be making on a typical basis. He's still entitled to apply, right? Like people that are essential can still apply because they're not making their typical profit.
Yes. Yeah, and it's kind of mixing two different concepts. The essential is whether you can continue to operate, and that's a state that comes out from a state, you know, Dr. Act inside this order, and that's where that comes from. The payment protection program is a federal law that is authorizing loans to people. You know, it's not going to give you, you know, all your profits and all your, you know, your vacation time and, you know, things like that. But it's sort of the basic expenses that keep you afloat. Your payroll, your rent, your mortgage payment, your utilities. That's what you're allowed to use that money for. So, all right, one last topic here. And that is, what if you can't perform? You have contracts with people and you're supposed to supply goods or services and you can't do it. Or you're supposed to make payments and you can't do that. We'll talk about that for a little bit. Let's talk about if you can't perform. You have a contract and you're supposed to do something and you can't do it. The question then becomes, is it a written contract or is it an oral contract? So if it's a written contract, what we lawyers would do is we would look for something called a force majeure clause or an act of God clause, and we'd see what it says. And many of those clauses, you know, it all depends on how you draft it, but many of them say that you can be excused from performance if a force majeure situation occurs or an act of God. And there's often definitions. Sometimes it says pandemic, sometimes, and, you know, frankly, a year ago, if I would have saw pandemic in there, I would have kind of snickered to myself and say, what pandemic? Now everybody wishes they had pandemic in their force majeure. But then they usually have a carve out that says, or other condition which was not reasonably expected at the time of contracting. So if you have a written contract, you can't perform, you want to look for your force majeure or act of God or excusable delay clause. If if you don't have a contract, a written contract, and you just perform by, purchase orders and invoices, or, just an oral agreement to do it, there was common law protections, and they're very similar to what you would write in a force majeure. But what the law says is that, that can be excused from performance if something happens that nobody expects at the time of contracting. And I think what we have here, nobody was thinking about this happening, coronavirus, at the time you entered into a contract, unless you entered into a contract last week. The ability to perform is either impossible or impractical. And the law differs a little bit, but you really have to have a hard time performing. And you're not at fault for having failed to perform. If you could have got goods for the last year and you didn't do it, and the last day you say, look, I can't perform because I can't get the goods, well, you might be at fault. But if you can hit all those factors, a court might say that you are excused from performance if you breach that contract. Now, it's just the next topic is what if you can't pay? Kind of what Molly was asking about. If you if you just don't think you're going to survive, what happens if you see your bills mounting and you can't pay them? Well, you've kind of got two choices. This is sort of more practical advice from having done this for years. But the first choice is you have two camps. I was calling it to myself. One camp is you take the bull by the horns, and that is you actually call up that creditor and say, look, I can't pay. And some banks and some bigger companies are allowing people to delay payments. But if it's more of a kind of a small business, or suppliers and vendors, they might not have a program or might not be able to handle that. If you go call them up and say, look, I can't pay, let's work this out, I always kind of recommend that. To me, that's the way to handle it. I always think that if you can work out a deal, that's good. If you can get it in writing, that's better. And then, I figure too, I've always assumed and told clients over the years that if you can make a commitment to pay something, you're in a bad situation. I've had times where clients have said, look, I will pay you $100 a month until I can get better. And I think things will get better. But, creditors might say, sure, if you pay $100 a month on the 31st of every day, we'll stand down and we won't do anything. And you do that then. You go and do what you say. And a lot of creditors will take that into account, and, they'll work with you, especially under these circumstances. But what happens though if you try to work out a deal like that, or you take the second view of this all, the second camp I was calling it, which is the better to ask for forgiveness and permission, and that's just ignoring them. Sometimes the guy on the other side is just difficult to deal with, and you might have a hard time making it work, and you have nothing to say. I don't always recommend that, but that's sort of the other camp. You can either try to work out a deal, or you just let them come to you. If they come to you, what's that going to look like? Well, usually it is a demand letter. Okay, and I've written 100 demand letters in my time, maybe more. And it really is, you owe us X amount of money. We hereby make demand on you to pay this within X days, or we will file suit in the court of common pleas, or blah, blah, blah. That is what you will see. And for the most part, because again, that creditor still wants to get paid. So they're going to give you a chance. You can take that demand letter and try to work out a deal with them, or you can ignore it. Again, you kind of ignore it at your own risk. You might consider, bringing to an attorney at that point. There's times where, people send demand letters and then they don't do anything further. They see if they can shake out a little bit of money, but they don't want to spend the money on a possible lawsuit, or they don't want to spend the money on lawyers, so they let it go. But what happens if this person doesn't? I can tell you too, when I write a demand letter, I will usually say, pay us within 10 days or we're going to file a lawsuit. And as every good lawyer does, we're all bound on, dates. I will put it on my calendar in 10 days hence, and it will say, sue Bob if he doesn't pay Phil, And when that day comes up, it doesn't take a lot for me to put a complaint together. So I will do that. So, if I file a lawsuit, what's that going to look like? The first thing you're going to get, and I guess another way of saying this is, how do I know I've been sued? If you get a letter from a creditor saying pay us within 10 days, that's not a lawsuit. You might even get a draft complaint. It might say complaint. It might say in the Court of Common Pleas. That is a draft complaint. It's not a lawsuit because it's not been filed. The way you have a lawsuit is that it's got to be filed with the clerk of courts, and then the clerk will serve it. And you'll know when you get sued because it's going to come either by certified mail, it's going to come by FedEx, or it's going to be personally served. So you get the guy comes up and says, you've been sued. So you'll know when it happens. When that does happen, that's the part of the time where you can't be in that camp anymore, the better to ask forgiveness. I mean, you've got a time issue. You've got 28 days. What you'll always get in that certified mail or that FedEx is a summons. So you'll get a summons from the clerk of courts, and it will say, you have been sued. You have 28 days to respond to this lawsuit, or a judgment may be taken against you. So at that point, you want to do something. I would recommend, calling your attorney and talking to him about that, and let him know that, give him a copy of the document. And then at that point, it's a question of most cases settle, and in cases like this settle, you're trying to work out a type of deal. If you want to go to court, you can, but, if it's really just a situation of you just can't pay because you don't have the money right now, most attorneys and most creditors will try to work out a deal because, what you get at the end of a lawsuit isn't cash in your hands. You get a judgment, which is a piece of paper that is worth about the value of that piece of paper. What you have to do is you got to collect on that judgment. And that's kind of a pain to do. So most creditors want to get paid, so they'll try to work something out. But recognize if you get that lawsuit, you've got to act, and it's you got to do something, or they will take a judgment against you, and then they can try to get you to collect, and that's just a big mess. So the last part of this piece is kind of the question that Molly raises: what happens if you don't have one lawsuit, but you got 5 lawsuits, and you can't pay any of them, and the creditors are swirling? That's where bankruptcy comes in, and that's pretty complex, and you really need to talk to a lawyer if you're considering bankruptcy. But other than that, that's the end of that topic. Are there any questions on that, or are there any other questions generally?
We do have a question from Barb. Once the application is completed, we take it to our local banker and they submit for the loan, and that's a question, and that's regarding the Paycheck Protection Program.
Yeah, that is a process that's still being worked out, and it's again, my contact at Huntington said they're still working, and that he's supposed to give me more information when that comes down. I don't know that he's received that as of today, but that sounds like it makes sense to me. But I just don't know what that process is right now for sure.
Thank you very much.
Yeah, I hope it's been helpful, and with people having spare time, it's good to start digging into some of this stuff because it's complex. Our firm is available to assist, but there are lots of good law firms around our area, lots of good chamber member law firms who can help out. And, I think everybody's just trying to really just, lock arms and get through this. So God bless, and everybody stay safe.
Thanks, Henry.
Thanks, Henry.
All right.
And folks, this is recorded. So I do, like I said, edit it just a little bit, and then it'll be up on cvcc.org. There's a whole link of all our virtual Zooms. So you guys have a great whatever day it is, and we'll see you all later.
Thank you.
Very good.
Good job, Henry.
Thank you.
Thank you for the work you had to put in to do that.
A lot of lawyers have been working fast and furious to get up to speed on this. But you're getting calls,